Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. Ann and I are back. Ann Lipton is a law professor at the University of Colorado who teaches and researches securities and business law, and she holds up the legal end of our podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Hey, Ann, did you know that this week is the 1-year anniversary of this podcast?
I did. That seems like a very long time. I haven't realized it's been that long. Wow.
Yeah, it was a year ago. I mean, we started talking about it,
Yeah.
Probably a year, much longer than that.
Yeah.
But the first one was recorded and posted the first week of September 2024.
Wow.
And
I can't believe we've kept it up that long.
I know. We get along pretty well. And this is number 44.
Wow.
Out of 52. So I think we've pretty much, kept up this kind of weekly, as we say, cadence.
We've taken little breaks, but mostly, yeah.
Right. So, quick reminder about our mailbag. I don't know if you want to give the email.
Sure. So we will respond to questions or things you'd like us to talk about. You can just email us at shareholderprimacy, one word, at freefloat.llc.
Cool. All right. So I don't know. What do you want to talk about this week? What's been going?
How about our favorite subject that we constantly are coming back to?
What's that, Ann?
That would be Tesla. Once again, it would be Tesla.
Let's talk about Tesla. We haven't talked about it for a number of weeks. Part of the reason is we haven't podcasted for a number of weeks. Yeah. But we did talk about it, I think,
in August
when they first announced the date of their AGM. But now they've actually put out the agenda for the AGM. So we'll cover that. But before we get there, there's actually an adjacent subject that is worthy of an update, and that would be the Detroit case, the one that I got myself inveigled in, because there's been some developments there, and they bear on a little bit, as we'll talk about the AGM that just got disclosed. So why don't we cover Detroit for a little while, and then we can go to the AGM. Make sense?
Okay.
All right, cool. So, as everyone who follows us knows, there's been a couple lawsuits we've talked a lot about. The first one is Tornado, and the only thing really to mention there is that everyone knows it's on appeal to the Delaware Supreme Court. There's a lot of argument that's going to be made. Well, that appeal was scheduled for oral argument on Wednesday, October 15th, so in 5 short weeks. There's all sorts of arguments that are going to be made and all sorts of subjects that will be argued, including whether Elon Musk controls Tesla, what kind of legal fees. One of the big things is legal fees.
And of
if
course,
anybody,
whether they're going to restore the pay that
whether pay gets restored. Exactly. Now, importantly, I didn't know this, but at least this one, but I think many Delaware Supreme Court argument or oral hearings are broadcast. They're available. They're available
on the web,
online.
and they're stored. So, like, even if you can't watch it at the time, you can watch it later.
Yeah. So I have that date circled to listen to that one. So that's Tornado. But let's talk about Detroit for a little while, because there was some really cool stuff that happened, or cool, interesting stuff that happened. And I think the headline there is that based on some of the evidence that has kind of come out in the appeal to the Supreme Court, it looks like it's possible that the Tesla directors told some lies to the Delaware Supreme Court. Now,
seriously?
whether you want to call them lies or whatever, misrepresented stuff, but there's a fact pattern that emerged here that is worth describing. Okay. So I can't remember last time we talked about Detroit, but
we talked about this quite a while ago. But you were challenging. It's a challenge to the director pay.
Yes.
And you were challenging the terms of the settlement. So this
Correct.
is separate from the Elon Musk pay. It's the director pay.
Absolutely. Right. And so that was a settlement. It wasn't a trial. And Chancellor McCormick approved the settlement over my well-conceived and well-thought-out and brilliantly written objections.
Of course.
In January. And just to recap, the settlement was for $735 million in cash and options, or cash and equity, and there were some corp gov reforms.
Right. So they were supposed to.
parties agreed to.
So the whole thing here was that the director pay was not properly, voted on by shareholders, et cetera. Shareholders
Yes.
sued, and they settled, and they said they were going to return the pay. Is that the idea?
Yes, correct. They were going
So
to
the
pay
settlement
back roughly
was
a
that
third
right,
of
so-
what they'd received.
So the settlement was directors were going to return at least some of what they'd received in pay,
Yes, right.
because their pay was challenged.
Correct. And then they were also going to allow shareholders to vote in future years on director pay.
Okay.
So, right. And there are a couple other corp gov reforms. But that shareholder vote was very interesting because that's unprecedented. Anyway, so I read the settlement. I didn't like how some of it was expressed, and so I wrote some objections to Chancellor McCormick. Again, as you heard, she didn't like what I had to say or didn't agree. And my objections were twofold. The second one had to do with whether that shareholder vote would be enforceable. We'll talk about that another time. One of the objections had to do with whether the directors were going to pay that settlement, as Chancellor McCormick put it, ratably. Whether they were going to allocate it among the directors kind of commensurate with what they'd received.
Because you were afraid that like Elon Musk would just pay it or something.
Right, or Larry Ellison or somebody. Right, and that
Right.
would create some unbelievable conflicts. And there's, while all the directors on that board, have some decent, wealth, some are much better able to pay for that than others. So there was this concern. It wasn't disclosed and so forth. So I appealed that, and Chancellor McCormick at the time actually said, "Oh, that's a very good point." She said that in her presentation, but declined to kind of reopen the settlement to try to accommodate this. So I didn't like that. So I then appealed this to the Delaware Supreme Court, filed the appeal. I did it pro se again, so I represented myself, which was kind of fun. So I had to learn. I'm sure you're familiar with this.
Yeah,
I had to learn how to write an appellate brief, and so I copied a bunch of people and talked to some lawyers and said, "This is how this looks." So there were three briefs. There was an opening brief that I wrote, and then the parties, the defendants wrote an answering brief, and there were actually two answering briefs that were submitted. One from Tesla, the company, and one from the directors themselves. There's 10 defendants that were directors at the time that they got this.
And incidentally, we should mention that the reason for the appeal originally was because they were objecting to the attorney's fees that were awarded, right? Because it was a settled thing. So there was an appeal that was basically the director saying, okay, we're fine with the settlement, we just challenged the attorney's fees. And then you also appealed the settlement
my appeal was
itself
separate, yes.
because you didn't like the settlement itself.
Right, and Tesla in fact did that. Tesla company appealed the legal fees that the plaintiff's attorneys were looking for, which was somewhere over $200 million. So they're trying to knock that down. So in all this process, some interesting facts kind of emerged that I want to try to recap here. Tesla had said, sort of separately, in a sworn affidavit to the court, that it had received the $735 million from those 10 directors, that in fact it had deposited that money, or deposited some of the money, and also had some of those directors return unexercised options. So the settlement allowed the directors to pay in three parts: cash, return unexercised options, or just give up shares. And evidently, according to this affidavit, they did A and B, cash and returned options. Okay, and that happened. That affidavit was dated like February 26th of this year. So sometime by that date, Tesla had received all that. Okay, now you got to know, of those 10 directors, 5 are still on the board of directors at Tesla. That includes, I think, James Murdoch, Kimball Musk, and like 3 others. Robin Denholm. Okay. So if they were going to return options, unexercised options, they would need to disclose that. They would need to file an SEC Form 4 to show that they had relinquished those options. To show, like any other chain, when they buy stock, they have to file Form 4. When they sell stock, and when they get or receive or cash options, it all goes in Form 4. Well, I filed I mentioned there were these three briefs: opening, answering, and then reply. I filed my opening brief on March 31st. As of March 31st, there was no Form 4s on record.
So they said
for those
that
three,
they had,
right?
So they had said that they had returned these options on February 26th. But when
Yeah.
you filed your brief on March 31st, they had not disclosed that in a Form 4.
Correct. Now, there's all sorts of things that could be going on, but I'll talk about that in a minute. Okay. So then the briefs kind of went back and forth. The defendants filed their answering brief, and they filed the answering brief a little after May 1st. But on May 1st, 5 Form 4s showed up
Finally dropped.
on Edgar. Okay. And the company said that, there was the delay. They had to wait to sort of read my opening brief. They tried to explain this delay, but I don't think they did a very good job of it. But anyway, so the Form 4 show up on May 1st, and essentially Tesla said that the board had to meet to cancel the options, which is fine. I don't know how that works, but there's probably some good governance practice, or maybe there's Texas law. I don't know how this would work, but anyway, so assuming they filed these Form 4s in a timely way on May 1st, the board met, either like April 29th or 30th. You got to file a Form 4 within 2 days. Okay?
Okay.
So it is literally impossible
that they
for Tesla to have received the options on February 26th, but for the directors to have conveyed them to Tesla on May 1st or April 29th or 30th.
Wow.
Okay? So either
it's not like these people don't have a history of not filing forms.
Oh, right, absolutely. Well, so either the sworn affidavit from the chief accounting officer at Tesla was wrong. I can't believe that's true. Okay, or the Form 4s were wrong or late, but that's not what Tesla said.
Yeah, so something.
Okay.
Yeah.
Or something happened between February 26th and May 1st where Tesla did receive the money, but they didn't receive it from these 5 directors. I don't know what.
Yeah.
But and Tesla all through this process was saying, no, we're going to pay this. Everyone's going to pay their fair share. We're going to pay it ratably, and that does not appear to have happened.
Wow. I don't know.
So I defy Tesla to explain how they received something on February 26th, but the people who paid it didn't pay it until May 1st. It was kind of like a form of time travel or something.
Yeah, I don't know how any of it works. As I said, all I know is that, going by Elon Musk's history, late filings are not...
Yeah, right. So yeah, but again, I don't think, and Form 4s get filed late all the time, and the SEC overlooks it. And Form 4 enforcement is just not that strong. So, but Tesla was really clear in these pleadings that they waited for a board meeting. And you know what we should do is, I don't know how books and records work in Texas anymore.
Yeah, no, you can't. Well, you can't get them in anticipation of litigation.
Oh, okay.
That's
I just want the minutes from the board meeting. I want to know.
Yeah, if it has something to do with litigation, you're not allowed to get books and records in Texas now that with their new law.
So anyway, the upshot is there's this little potential misrepresentation in place, but alas and alack, there is not going to be any oral argument about my objections.
I am sorry.
The Supreme Court declined to hear oral argument on those the two things I objected to. They will hear oral argument on the legal fee dispute.
On the legal fee issue, yeah.
That's, I think, scheduled for October 29th.
Yeah, so it's after the appeal on Musk's pay.
After Tornado.
Yes,
right.
Yeah, and both of those cases involve attorney's fees, so the court might sort of try to reconcile how
I think they might be trying to sort of the court might be trying to think about that stuff kind of at the same time.
Yeah.
If only because it's two of the absolute biggest legal fee awards.
Yeah, and
ever.
Against the same company, shockingly.
Right, exactly. So that's my sad tale. Not so sad about this, and I'm sort of waiting for someone to sort of try to dig into this and sort of see what happened about how Tesla could get something before people pay it. But anyway. So that's the status of Detroit. We'll know more probably in January, is my understanding. It takes the Supreme Court is pretty quick about issuing their rulings here. So we should hear about this in the next 2, 3, 4 months. So anyway, there's more to talk about with Tesla. We got a whole AGM to discuss. The proxy statement just came out last week. So why don't we do that? But let's do that after a break.
Okay.
Sound good? All right, cool. We'll take a break here and come back and talk more about Tesla here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin, and we're going to talk more about the annual general meeting, the AGM at Tesla, which we talked about a couple of weeks ago when Tesla set the date and when they handed Musk 96 million shares of stock. Right. So there's a lot of different things on the agenda. We've got director elections. We've got the legally required say on pay. We have auditor ratification.
We had to ratify the auditor. That's always my favorite vote.
It's a critical vote.
Right.
And then we have a bunch of shareholder proposals, and we have more on Elon Musk's pay.
Right. So, actually, there's pay, and there's another sort of interesting another company proposal. But let's talk about the shareholder proposals, because you know Tesla's a magnet for this kind of stuff.
Lots of people like to submit proposals.
Right. So there are now 10 for shareholders to vote on and think about, and for the proxy advisors to analyze.
Yeah, and I think actually some of them say that they have a request right now pending with the SEC to exclude them, so I'm not even sure all of them.
Oh, that's interesting. Oh,
yeah, I'm not sure all of them will show up.
Maybe. Yeah. Oh, yes. Some of the 10 may not make it to the definitive
floor,
proxy.
so
it's worth noting that what we saw last week was the preliminary proxy.
Right. Yeah.
So some of the, it's not just going to be punctuation that's going to change. There may be some substantive changes.
Yeah.
To what's there, but currently there's these 10 shareholder proposals. Since that's I guess on top of, there was a report last week that there were another 11. Oh. Someone went to you can look, I don't know if you know this, you can go on the website and go look at all the no action letters. There were 11 that Tesla had succeeded in excluding from the agenda. All right. So of these, there are, let's deal with some of the smaller ones. There's one on child labor.
Yeah, and it's from NCPPR, which is surprising to me.
Yeah, the National Center of Public Policy Research. Yeah,
because they're a conservative organization.
They're total anti-woke, anti-ESG.
Yeah, I know. So I'm not really clear on what the motivation is for the child
I don't know.
Proposal,
if you read it over, any big public pension fund could have written that one. It's
I don't understand the motivation.
The bedfellows are getting a little strange here, and that might, that's got to just irk the hell out of some of the conventional proponents that NCPPR is the one who was able to get that one on the agenda. All right. There's another one on investing in XAI, which of course is Musk's AI and Twitter X.
Yeah. Exactly.
Company.
So a shareholder is having a proposal that the company should invest in XAI, and it's non-binding necessarily.
Yes.
I mean, and Tesla is taking no position on this.
Yes.
Actually. There's no position.
Right. They're not telling how to vote. I mean, for all the other 10, Tesla's emphatically opposing and written very detailed. Well, there's one or two others that are also I think it's the company proposal with the yes, but all those 10, the company is just opposed, except this one. Where they're just neutral.
They're just neutral, but it's just, I mean, obviously, they don't, and Matt Levine keeps pointing this out, you don't need a shareholder to propose this. If they want to invest in XAI, they can just invest in XAI.
Right.
You don't need a shareholder. If they want shareholders to vote on it, they can propose that.
Right, and they kind of deflect a little bit, say we're going to think about it. If this shareholder proposal passes, we're not necessarily going to invest, but so there was that. There were a bunch of the other usual ones from John Chevedden had one, and Jim McRitchie, guys we know and like.
Yeah.
There were two others that kind of warmed my heart slightly because they were bylaw amendments.
Nice to see them.
I know there were. Well, I've long argued that anybody who proposes something precatory should be proposing something that's enforceable, like a bylaw amendment. So there's now 2 of those, and these 2 respond to one of your favorite recent subjects, which is changes in the Texas statute that basically make life hard for shareholders. So one of these bylaw amendments that a shareholder has proposed is basically just to repeal an earlier bylaw amendment that the company had passed, and that one had to do with shareholder derivative lawsuits.
Yeah.
So Texas, and you have to check me on this, Texas allows a Texas, I'm using based, I don't know if that's the right adjective, because it's not just domicile, organized,
No,
thank you, organized Texas. Well, Tesla for sure is not only organized, they're domiciled and headquartered and operate in Texas. So Tesla qualifies. But if a Texas organized company wants to, it can limit derivative lawsuits to 3% or greater shareholders.
Right.
They
yeah.
just have
we
to pass,
had mentioned this
right,
before.
Right. We talked about this.
With that.
Right.
Yeah. So now Texas allows it, and Tesla took advantage of that to pass a bylaw that says if you want to bring a derivative lawsuit, you have to have at least 3% of the company, which in Tesla's case is around $30 billion. Nobody does have.
Yeah, no one's going to come close to that.
Right, exactly. So now the New York State and the New York City comptrollers who control, the New York pension funds have a shareholder proposal that would be binding because it would be a bylaw repeal if it passed to repeal this bylaw.
Yes.
So that's one.
That's the first.
Proposals.
The other one has to do with shareholder proposals.
Yeah.
Because Texas, similar to this minimum for derivative suits, says there's minimums that we're going to allow companies to observe for just to submit shareholder proposals, which will put a lot of this ESG.
Yeah. So I think we mentioned this, so it's a very strange law. Like, first of all, it doesn't apply to Texas organized companies. Let me say that again. It does not apply to Texas organized companies. It only applies to companies that are headquartered in Texas or that are listed on the Texas Stock Exchange, which isn't a thing yet. If you're headquartered in Texas or listed on the Texas Stock Exchange, they have a new law that allows you to limit shareholder proposals in various ways that go beyond what federal law does. And there are 15 billion questions we can ask about their legality, of this law, but it's a law, so we've got a shareholder proposal asking Tesla to not take advantage of this law. Yeah,
right. To amend, essentially, it's kind of meta.
Yeah. Well, it's if they take advantage of it, they'll only do it with shareholder approval. Something.
Right.
Like
exactly.
That.
So if Tesla wants to do this, they have to gain shareholder. So it's basically amending the part of the bylaws that require that for shareholder driven amendments. Yeah.
Exactly. If they decide to take advantage of this Texas law that would allow them to limit shareholder proposals, they have to promise to get shareholder approval of that, and it would be in this bylaw form. This proposal is in a bylaw form. Right. Now, Mike, you might like it that.
I love bylaw amendments.
You like bylaw amendments. The problem with Tesla and bylaw amendments is that Tesla's documents I say that if shareholders pass a bylaw, it has to pass by 2/3 of the outstanding shares, which is not true of a non-binding proposal, because a non-binding proposal is just a statement of sentiment. So essentially, these are not going to pass.
Oh, these aren't going anywhere. Wait a minute.
They aren't going anywhere if for no other reason than you would have to get 2/3 of the outstanding shares to vote in favor. There are probably other reasons. But here's the thing, and this is very much my thing. So they would have to get 2/3 of the outstanding shares to pass. They will not get that. And at least one of the reasons why they won't get that is because Elon Musk gets a vote. Kimball Musk gets a vote. The board gets a vote, and they hold a lot of shares, so it's not going to get there.
There's close to 18 or 19% at that point.
But
just insiders.
Yeah, more than that now.
Right.
Yeah. So I think, well, actually, but what it comes down to, though, is I have had this thing in that I've wanted forever. I will never get it, but it's what I want. They will report eventually the vote totals, and when they report them, they're just going to have shares for and against and abstain.
Right.
I think the SEC should require that they break it down by insider votes versus public shareholders.
Yes.
I mean, you can sort of calculate it, because if you assume the insiders all voted the same way and you know exactly how many shares they have, you can figure that out. But I'm relying on people like you to do that, because I can't do that math. It's just too complicated. But I think that I would really like to know what the public shareholders thought of this.
Yes.
And I'm going to have to rely on you
right.
to break down the vote totals and figure
having
it out.
some sort of SEC blessed like format
when it's actually
that
required to break it down.
Yes, that would be. I would love that.
Yes.
That would be very interesting to see. Huh. Well, yeah. Either way, like I said, these two bylaw amendments, I was pleased that someone thought to amend the bylaws rather than just Xerox
rather than just
another
precatory. Except that also raises the threshold, so it can't pass.
Well, but that brings us to one of the three company promoted proposals, which is to remove a supermajority voting requirement.
Yeah.
Okay, so this is it's like number 8. I can't remember this.
Yeah,
with 16 things on the agenda.
They're putting it on the ballot, but they're not actually recommending in favor. They're just putting it on the ballot.
Right.
To remove the to remove
this is an actual,
which is also for their charter amendments as well.
Right. So this is an amendment to the bylaws and to the charter of certificate of incorporation. Okay. And it requires 2/3 approval right now, but they're going to then dial back on the supermajority. So anything going forward, assuming shareholders agree with this, and we're not clear that they will, things will only require simple majorities, like to amend the bylaws, to call a special meeting, to act by written consent, things like that.
To change it from a staggered board to a single class board.
Right, exactly. So now Tesla argues, and this is where I think this is a little insincere. Tesla says, we've wanted to do this for a while, but we were waiting for enough shareholders to kind of want this.
Yeah, that's very silly. They could have done it when they moved to Texas, as part of the move to Texas. And then they could have done it with a simple majority. And ISS actually criticized them for not putting that in the Texas charter when they moved to Texas.
Right. So and the other kind of funny thing here is that now, and Tesla says, okay, finally last year at 2024, because of this ratification of the Musk comp plan last year, we finally got 2/3 of the shareholders to show up to a meeting, and now we think it's okay to put this on the ballot, on the agenda, but now that it's there, the board doesn't take a position.
Yeah.
But I mean, the board's the one that approved this proxy.
This would be a great place to see the breakdown of insider versus outsider votes.
Right. All right. So there's this one, and by the way, I mentioned John Chevedden had proposed. One of his proposals is on the agenda. He has a precatory, non-binding one, basically to remove all the supermajority stuff. So there's a little bit of redundancy going on here. Yeah. All right. This takes us to what I think at the meeting is going to be the main event, which is the two proposals pertaining to Musk's comp.
Yeah.
And now one of them amends the earlier pay plan,
so,
and then the other one's new. Let's talk about this. All right.
Yeah, we talked about this in our previous, when we talked about the Tesla thing, like our last Tesla we talked about this. So remember, so what happened was they had, in 2018, they gave him this big, massive grant, the one that Delaware rescinded.
Yes.
In 2019, they created a new employee compensation plan, a normal one that would just give stock to employees, as part of their compensation, that explicitly said they didn't expect it to apply to Elon Musk. The reason it wouldn't apply to Elon Musk was because he had just gotten the 2018
Just gotten the
grant.
one the year before, right.
Right. And there was some maximum amount that they could dole out under this 2019 plan. Now, that 2019 plan had to be approved by shareholders in 2019. And the reason it had to be approved by shareholders was even though normally compensation decisions are board decisions, you don't need shareholder approval, it actually legally needed shareholder approval because the NASDAQ has a requirement that any comp plans that include equity have to be approved by shareholders. Okay. So they had it approved by shareholders in 2019. Fast forward to 2025, they decide they want to make sure that Elon Musk gets his pay back if the Delaware Supreme Court agrees with McCormick that it should be rescinded.
Right.
So they use.
So if they lose the Tornetta
exactly.
case, basically.
Exactly.
Yeah.
So they decide. So they decide to award Elon Musk shares under the 2019 plan, because that way it doesn't need a shareholder vote, because the 2019 plan was already approved by shareholders in 2019. So they could avoid a shareholder vote by saying, oh, this isn't a new equity plan. This is the old plan. We're just using it for Elon Musk, even though at the time they said it wasn't going to be used for Elon Musk. And they handed him 96 million shares in August. And one of the things we said about it was, because they used the pre-existing plan, they didn't have to get a vote under NASDAQ rules. And they don't need to worry about anything to do with like fiduciary lawsuits in Texas, because they passed this 3%
That's why they live in Texas.
Exactly. So he gets 96 million shares. Fast forward to today. 96 million is not enough to make up for all that he'll lose if he loses Tornetta. So they are asking shareholders to amend the 2019 plan to allow them to give Elon Musk even more shares in case he loses in Tornetta, to make up for all that he lost in Tornetta if he loses. And they are also amending it because they gave him so many shares earlier this summer that there's nothing left for the employees.
Oh, they ran out of shares in the plan.
Which just shows you it was never intended to be used for Elon Musk. They ran out of shares to give the other employees, so they're asking shareholders to vote to expand the plan so that other employees can finally get the stock that they plan to give them.
Right.
So that's one proposal. And the next proposal is the go-forward plan.
Okay, before we talk about the go-forward, just to make sure, so what shareholders are going to be voting on is not whether Musk should get this makeup or whatever. That's already been decided. This is a vote to amend a mechanical amendment under the 2019 plan that's the vehicle.
Yeah.
So that there's just enough shares to get available for the
authorizes to give Elon Musk. But here's the thing about that I really want to point out. Let's say you don't think Elon Musk should get his old pay package back if the Delaware Supreme Court, if he loses in Delaware. Let's say you don't want to give him back. But you do want the other employees to be paid. That is not an option for you. You can't. There's one vote. It's amend this plan. And amending the plan does two things. Allowing the board to pay Elon Musk the shares that he lost in Delaware, and creating enough shares to pay the other employees. There is no way to split your votes on that as a shareholder, which is, by the way, an issue under SEC rules, which say you're not supposed to bundle that way. But it's not like anyone's enforcing anything.
No one cares. No one down there cares about that stuff. Right. Yeah. So that's what me. I'm a Tesla shareholder. That's what I'm going to be voting on when I vote on this one. And now there's the 2025 plan.
Then there's the go forward plan. It's the new, which we were all waiting for. Like, what are they going to do for going forward? And this new 2025 plan, it's another like sort of massive payouts for massive results.
It's going to make him a trillionaire, right?
It'll make him a trillionaire. So like it's in tranches, just like the last one, and with market cap goals. And if he achieves each tranche, then he gets
some operating goals. To be fair, there's some operating goals.
And, and that's the thing that like what's different from the last plan is the last plan was just stock based on basically rises in stock price
and share price.
And there were some like EBITDA revenue stuff, but nobody took that seriously. But this one has some serious operating goals.
Oh yeah, he has to like hit. And I've read some criticism that these goals are really not that big a deal. That you're supposed to get to like 20 million cars manufactured in aggregate, and they're already.
Well, it's something like 12 million cars to sell 12 million cars, get 10 million autonomous driving subscriptions, and 1 million robo taxis, and 1 million AI robots. Yeah. So I mean, I don't, over time. So I don't, I don't really have particular opinions on whether these are reachable or not. I know that the board, though. They warn you in the proxy, the board has a lot of flexibility to decide when these goals are met, which is already like your first hint.
I love that. Yeah, right.
Yeah. But yeah, so there are these big market cap milestones. And the first one is in 10 years, he's got to double the market cap to $2 trillion. Which, I will leave it to others to talk about whether that's achievable.
I'm a skeptic,
well, Mike, you are not taking into account the effects of inflation and the devaluation of the dollar. Maybe he doesn't do anything and just the dollar sinks that much that it's $2 trillion when it was previously $1 trillion.
Right.
I don't know.
Maybe. If that happens, we'll have a lot bigger problems than the fact
if that happens, we're not going to be thinking about Tesla anymore. Yeah.
All right, so
I want to
go ahead.
point out though that like nothing here, like the previous one, nothing here places any kind of restrictions on him. I mean, he has to stay with Tesla, but other than that, he can work at his other companies. He can still do politics. The hope is just that given these incentives, he's incentivized to focus on Tesla. So, for example, Tesla is competing with XAI for AI stuff. Presumably, the incentive here is that he'll focus on AI at Tesla rather than XAI, because at Tesla he gets these $1 trillion rewards if he sells self-driving cars or whatever. Except the problem is, and this is the point that Matt Levine points out, does XAI bid now? Oh, Tesla's going to give you $1 trillion for if you build AI. Well, if you stay with XAI and build it, we'll give you do they just bid against each other?
Well, the difference there is that there's all the backers of all those other companies are they don't have quite the money that Tesla or the stock.
I don't know what kind of
the
idea that they're both competing to get their CEO to focus on them.
The focus is a little weird.
All
right, go ahead.
No, just also there's a shareholder proposal that is asking Tesla to stay out of politics, which of course the board recommends.
Right, it's one of those other 10. Yeah. Right.
Other than that, though, the only mention of politics in the proxy is buried all the way down in the special committee report, where the special committee report mentions that they think that this pay package will also incentivize Musk to wind down his political activities in a timely manner. And maybe it will. I mean, as far as I know, actually hasn't been all that involved directly in politics. But the political problem with Musk isn't I'll create a new party or I'll donate to Trump or anything. Right now, the political problem with Musk is that a couple of days ago he tweeted out about declining white populations. I mean, this is the political problem.
Yeah,
it's no longer the direct
it's the impact. It's the impact of political activities on Tesla's business.
Yeah.
So I have one last question about the pay plan, or at least one more question about the pay plan.
There's more.
There's more today. Why in Texas, for the new one, the 2025 going forward, why is shareholder approval either desired or needed or it's not?
Yeah. So this is the same thing as this is the NASDAQ problem. So they know they're not going to be sued by shareholders. They know that they are not vulnerable to derivative lawsuits. So as the only reason they need to have a shareholder vote, and they're being pretty clear about it, the only reason that they're having a shareholder vote is because they're admitting it's a new compensation package. It's a new compensation package for Elon Musk. And therefore, under NASDAQ rules, they have to have it approved by shareholders. But here's the thing. There are two things about this that are just fantastic. So first, they're giving him shares, not options, shares. And that matters financially, they point out, because an option, if you're not in the money, it's valueless. But shares, even if the stock price drops, they still have value. But here's what's critically important. He can vote them. He can vote them as soon as he can vote them right away. And they're doing it, they calculated it out so that they give him shares that'll give him 25% of the company, which is what he's always demanded. It'll turn out to be 25% of the vote if he gets them. But it gets better. Because the 96 million they gave him in August, he can vote those too.
Even those are votable right now?
They're votable right now. They get rescinded if Tornetta comes out in favor of Musk. But he has them right now, and he can vote them right now, which means it lifts his voting power from 13% to 16%. And it gets better. Under NASDAQ rules, to approve a new pay package, they require a shareholder vote. But because this is not approval by the disinterested shareholders, the way it would be in Delaware, say, approval by the disinterested shareholders is to stave off a shareholder vote, a shareholder lawsuit. But NASDAQ just says that just anyone can vote. So under NASDAQ rules, he can vote on his own pay package. And he's doing it with an additional 3% that the board handed him.
And I didn't have many doubts that it would get approved anyway.
And nonetheless, it's still funny funny. They handed him an additional 3% in August, claiming it was under a previously approved shareholder plan, which it clearly wasn't. And now he has those additional 3% that he can vote to approve his own new pay package, which gives him more voting shares that he can vote as soon as he can vote them right away. But he promises that he's going to do mirror voting until they're earned, even if they haven't vested.
Oh, mirror voting, in other words, vote in commensurate with how the shareholders...
until they're earned. So once he reaches the milestones, then he can vote them however he wants to.
Wow. And I'm expected to try to understand and vote all this November 6th, aren't I?
Yeah. Oh, and also I should mention this. I really don't understand this. The 2019 amendment where they're trying to give the board the power to restore if he loses in Tornetta, it actually says, and this part makes sense, that the board's going to have discretion about it. And the reason for that is obviously, like, if they just hand him that many shares, it's a huge accounting issue. It's a huge tax issue. So given that, the board is not promising they will restore his pay package if he loses in Delaware. They're going to dole it out in their discretion. Okay, fine. Totally get that. But it also the board is not, as I understand it, they're not putting it in the 2019 amendments committing to only restore for his pay if he loses in Tornetta. Instead, they're making a separate promise in the proxy that their intention is only to restore if he loses in Tornetta. It's very strange. They're asking shareholders to vote on a plan that will give the board essentially unrestricted power to give him back those shares. And they're saying in the proxy, but we don't intend to do it unless he loses in Tornetta, except that's not actually
It's not binding on the Tornetta decision.
Yeah, and that's one of the warnings that they give you, that once shareholders vote in favor, the board has complete discretion to do what it wants. So I don't know what that's about.
All right. There are two other, it's worth noting, so there's 16 proposals to vote on.
Yeah.
All right. And we've talked thoroughly about a lot of these. And I'm pretty confident that 10 shareholder ones are going to go down. They're not going to get approved. I'm pretty confident that these pay ones will get approved. It's worth noting what's not in the proxy this year. There's like two things that caught my eye. The first is there once again are no dissident candidates running for the board of directors, which again I have expected for a while for that to happen. It hasn't happened yet. The other thing that's missing, which takes us back to the first thing we talked about, which is Detroit, is there's no compliance with the Corp Gov changes that they agreed to in the Detroit settlement. So they agreed to a better process for awarding director comp, more disclosure of the terms and amounts and so forth in director comp, and a vote on director comp for shareholders. So they've partially complied with some of the terms of the settlement because they got $735 million from everybody, though we're not sure who paid it. And that's still, I'm going to wonder about that for a while. But none of these Corp Gov change. But there's other parts of the settlement that they have just kind of blown off, or at least they're going to wait a year or something. I don't know.
Well, they're in Texas.
I was kind of
what
expecting.
Do they care?
Right, exactly. I was kind of waiting to be able to vote on director comp finally at Tesla, pursuant to the terms of the settlement in Detroit v. Musk or Detroit v. Tesla. I can't remember the caption, but that's not there either. So we're gonna have to wait a year to be able to vote on director comp. Wow. So that's it. That's the AGM, November 6th. Be there, or at least until they file definitive, probably in the next week or two, and then we'll know for sure what's on the agenda. Right?
Yeah.
Right. All right. Let's wrap up. How about it? We've talked about this
enough
until we have to talk about it again. We'll return sometime soon to Shareholder Primacy Tesla Edition. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is professor of law and Lawrence W. Demuth Chair of Business Law at the University of Colorado Law School. You can find me, Mike, at theactivistinvestor.com and Ann at lawweb, one word, .colorado.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening. We'll talk again soon.